pleasure, it's a great honor to introduce and welcome our next speaker, the barrister Sara Hossain from Bangladesh, who is speaking on this afternoon on surging sentiments, shrinking spaces, constraints, and social justice lawyering in Bangladesh. It's a real pleasure for me to introduce her. I've been a long-time admirer of her work, and so it's a great opportunity to finally get to meet her. I'd also like to thank the Center and our never-tiring director, Farina Mir, for making available opportunities such as this to meet people whose work, whose names we know but haven't met. So thank you, and thank you to the Center. Sara Hossain is a human rights lawyer and activist who is a major, courageous voice for justice for some of the most disadvantaged and marginalized of Bangladeshi citizens before the highest court of the land in Bangladesh. As a barrister in the Supreme Court of Bangladesh, and as the honorary director of the Bangladesh Legal Aid and Services Trust, which has a wonderful acronym called GLASS. I love that acronym. As the honorary director of GLASS, she was instrumental in drafting the country's first and perhaps most comprehensive legislation on violence against women, which came into law, I think, in 2010. She also has brought major landmark cases in Bangladesh, challenging forced veiling, the use of the fatwa to impose demeaning punishments on women and girls, the use of non-medical procedures to judge virginity tests for women in rape and sexual assault cases. And she has also, her Supreme Court caseload has also included work on disability rights and on workplace rights. She's been involved with numerous other organizations, human rights organizations, both nationally and internationally, a founding member of the South Asia Women's Fund, and a board member of the Enos Shalish Kendra, or ASK, that is probably very well known to most of us here. Her courage, her passion, her integrity has won the trust of her clients and the respect of the human rights advocates all over the world, nationally and internationally, that have awarded her several awards for her work. I think of the numerous awards that she's got. The latest was the International Women of Courage Award, awarded by the U.S. State Department. I think it last year. Last year, yes. Secretary John Kerry awarded her for that award. That's right. That's right. She also received the Young Global Leader Award by the World Economic Forum in 2005 and the Human Rights Lawyer Award by Human Rights First. Hossain's also been organizing various training workshops and programs for lawyers and judges nationally in Bangladesh and Nepal, as well as regionally across South Asia and the Asia Pacific, to teach people to use human rights law and mechanisms, including public interest litigation and the domestic incorporation of international human rights standards. And as if this was not enough, she's also published widely in her field. The latest work is an edited book called Handbook on Legal Remedies on Forced Marriage, another co-edited book, Honor, Crimes, Paradigms, and Violence Against Women. And she's the author, one of my favorite articles of hers, Confronting Constitutional Curtailments, Attempts to Rebuild Independence of the Judiciary in Bangladesh, in Paul Brass's edited Handbook of Politics in South Asia. I'd like to say two kind of personal things about Sara Hossain's oeuvre. She's one of the few people, I think, who really truly represents a slogan that I see at the bottom of her email address. I think it is a slogan of GLASS, am I right? Nyay Bikash Shokolay Ahikar Amader Angiro, which is basically translates into access for justice to all. And I think if you look at her work, she really represents that kind of commitment an unflinching commitment to a really expansive view of justice, not for particular groups, not for particular segments, but justice for all. So I really think it makes a very fitting speaker for our conference here. The second thing that I think is also really unique that she brings to thinking about legislation, policy, is that she's a lawyer. She works from ground up, from individual cases, from the petitions and the cases of individuals that she has dealt with to frame law, rather than the kind of abstract focus on policy that we see, especially now as states scramble to be politically correct with certain kinds of gender just laws. Thank you.
Thanks, Mrinalini, for that not just charitable but positively hyperbolic introduction. That's in a good South Asian tradition also. I think I need to start, like everyone, with thanking the quite extraordinarily efficient, organized, and remarkable Farina Mir, who dug us all out, got us together, and sustained politely but persistently her interest so that we arrived here for these 2 days. It's really a pleasure to be here, not just to have the opportunity to speak with everyone, but actually to have a chance to reflect on work that we do all the time, because there's really never a moment to sit down and put a few thoughts together, and this has been a really great opportunity to do that. But when I was thinking about what to say and what to reflect on, I thought more than talking about some of the things that have been done in Bangladesh in terms of social justice lawyering, or the history or the composition of groups and so on, I thought it would be important to actually look at the kind of current constraints that we face. And so I've organized what I want to say around that. But having organized all of that, of course, the last 2 weeks have been a very different situation. Just in the past few days, the attacks on the Rohingya in Burma and their exodus across the border and the demand that we keep hearing that they return rather than the focus on their safety and security have really highlighted, I think, the precariousness of communities in the face of extreme nationalism and colonialism. They've also reminded us of the very real need for solidarity across borders and for articulating and enforcing demands for justice and accountability. Inside Bangladesh, there's been a kind of unprecedented rainbow coalition of voices speaking out to condemn the violence against Rohingyas and to demand international action to bring to account those who are responsible. But different positions are being taken on how to respond to and ensure that the protection of the Rohingya community. Particularly interesting to see that the voices that are being raised are those of traditionally politically violently opposed groups, from the ruling party, ostensibly secular, to the opposition alliance, openly in alliance with fundamentalist groups such as the Jamaat, along with citizens groups and development organizations, and of course international organizations as well. Amongst the political leaders who are now very vocally offering shelter and calling for international action, ironically enough, many of them had up until only a few months ago been refusing entry quite consistently to Rohingyas, categorizing them as extremists, part of international terror, likely to infect the nation with the scourge of terrorism. And they'd also been denying access, again, consistently, to national organizations that sought to provide services to the Rohingya, whether health or education or legally. In fact, BLAST has been unable to provide legal services to the community for, I think, 10 years now, precisely because of these kinds of barriers. But alongside the stories that I think you have been reading about the kinds of efforts being made and about the ongoing movement, a story that has been little reported is one of two photographers from inside Burma, who, along with all of the international and national Bangladeshi organizations, came to document the exodus that has taken place and ended up being detained now and are now held in custody in Cox's Bazar jail. This small story has received very little attention, but I just wanted to flag it because I think it helps us to understand the kind of very contradictory streams within which we function and operate in our efforts to use the law to secure social justice. So on the one hand, we face the continued rise of religious extremism, a very pervasive fear, not unsubstantiated, of its further consolidation, and the threats and realities of violence carried out by extremist groups, including the internationally publicized cases of secular writers, academics, and activists, and the less well-known but persistent attacks on marginalized communities, including both Adivashis, indigenous people, and religious minorities. On the other hand, we face a kind of resurgent nationalism. Again, we're obviously not alone in Bangladesh, either in the region or internationally on this, but we see it manifested across different political alliances in different ways. Again, as I mentioned, while these alliances differ in their relationship to secularism, with the ruling party still ostensibly espousing this and the opposition rejecting it, both in practice have operational alliances and relationships with fundamentalist organizations. A nationalist sentiment of the secular variety, drawing on an evocation of the spirit of liberation from our independence war, has been harnessed effectively in many instances, for example, through the Shahbag movement in its initial phase, which many of you will know about, and its successes to counter extremism. But I would argue that the willingness to set aside, even in this movement, a commitment to universal human rights, while achieving, some would argue, a recognition of past injustices, has also contributed to undermining efforts to strengthen systems and processes of justice in the present day. But I won't dwell on that now. I think that's a longer conversation, and maybe for another time. But in parallel to these two streams that we see, the increasing undermining of constitutional bodies, the enactment and invocation of a plethora of draconian laws, and their arbitrary application to silence dissent and restrict public mobilization and protest, has resulted in dramatically shrinking spaces for movements for social justice. So before I turn to a discussion of some of the efforts that are ongoing to seek social justice through law and their limits and possibilities, I should just explain very briefly my own position. I'm a practitioner, really not an academic at all, despite occasional dabbling articles, and located very much within the mainstream in terms of private practice. But for the last 4 or 5 years, I've been working directly with BLAST, for the National Legal Aid Organization. We work with, like myself, volunteer lawyers across the country, and quite a number, 2,500 and counting, I think, across about a third of the country, and through locally managed offices run in conjunction with local bar associations and local citizens organizations. But just before I get to some of the examples of the kind of work we're doing and the kinds of constraints we face, maybe I should just take you a little bit through the broader legal framework and why I'm talking about space shrinking and how it's happening. Just before that, though, and just an image, I think, maybe to again remind us of the broad context. The image below, I think, will be very familiar to you from the last few weeks. The image above is, of course, Bangladeshis, Bengalis from East Pakistan, who became Bangladeshis, who just 46 years ago were marching in the opposite direction, east to west, from what became Bangladesh to West Bengal. And we're seeing similar situations, different interests, of course, militating how they're treated, whether they're treated as refugees or not. And apparently, Rohingyas are not being treated in that manner. Just quickly to take you to, for those of you who are not so familiar, and apologies to those who are, just a quick look at, I think, what is our constitutional framework and what are some of the kind of tensions that we inhabit. On the left, you'll see an image again from the Liberation War period. It's a sort of unifying slogan about Bengali nationalisms, which speaks across the diversity of religions, saying the Christians, the Buddhists, the Muslims of Bengal, we're all Bengalis. How does that get reflected later on, post-independence, in our constitution? Have a look. The principle, and the little summary I put up here is what is the position currently, what was it in 1972? You can see some bits have traversed through and survived, following different, I won't bore you with the history of different constitutional amendments and changes and Supreme Court judgments. Where we stand at the moment is secularism is still recognized as a fundamental principle. There is a ban on political parties based on religion, despite which they continue to exist. There is a recognition of freedom of religion, recognition of prohibition and discrimination. But interestingly, Islam is a state religion, brought in by the military but retained by democratic government, the current government. Bengali is recognized as the national culture, as the national language, but there is now a recognition of not of Adivashis as such by name, but of a term called small ethnic groups, reviled and considered absurd, of course, by Adivashis, but retained, unfortunately, in the constitution itself. I just want to spend a moment looking at this issue about Islam being in the state religion. I can see quizzical looks, and very understandably, I think, how does that sit, right, with secularism, with the prohibition on religious political parties and so on. This was brought in, Islam was brought in as a state religion in 1988 under General Irshad. It was challenged then and there by a coalition of eminent citizens, a former Chief Justice, a leading poet, leading writers, intellectuals, and so on. But for strategic reasons, that case wasn't moved in 1988 because there was a real fear that the courts would actually just stamp their seal of approval on this. And it was kept very strategically, again, in very time-honored South Asian fashion for a couple of decades to just ferment and improve itself. And then it was finally moved in 2011 when there was a sense of confidence that perhaps under the Awami League-led government, with its commitment, stated commitment to secularism, this challenge would now be successful. And initially it looked like this was going to fly. But then, again, I will not bore you with the background, but then this movement of the Hifazat-e-Islami, a madrasa-based fundamentalist group, no commitments to parliamentary democracy, and the slogan you'll see in their hand says, no Islam in the Constitution, Islam will be the Constitution, started demonstrations saying that if this hearing was to go ahead, they would besiege the court and do everything else possible. So in that context, a strong message went out that this case really shouldn't proceed. And suddenly, lo and behold, we all showed up for the hearing in my junior-most capacity in the team and so on, only to find that the court had said that no one had any locus any longer of the petitioners because a few of them had died. And also their conglomerate, the 10 or 11 names who were there, were not registered as a body. This in a country which, like everyone else in South Asia pretty much, will accept almost anything and everything as a public interpretation. From something that just barely breathes can walk in and say, I'm filing, I'm concerned. The report will accept it. Suddenly, all these eminences didn't come to the spot and the case was and of course the constitutional amendment and the new one also prevailed. What does this imply then? What have been the changes that we see in the law as a consequence of this? I mean, some people argue that, it doesn't really matter about Islam being the state religion because other groups can perform their and practice their own religion. It doesn't really affect anybody. But actually the interaction of this constitutional provision along with specific legislation, both colonial and post-colonial and post-independence, is where the real problems lie. So all of you from other South Asian countries are very familiar with the penal code provisions on hurt religious sentiment and prescription of materials and so on from the CRPC and the penal code. The really problematic stuff that we're getting in now, post-independence, is similar kinds of concepts, but being encoded without any of the minimal safeguards that were in place under colonial legislation. So if you look at, for example, one of the real problem laws we have at the moment is the ICT Act, the Information Communication and Technology Act, which effectively prescribes certain kinds of online speech. It deals with online hurt to religious sentiment. If you get done for that, you're not in for 2 years as you would be under what the British left us. You're in for 14 years rigorous imprisonment, no bail, arrest without warrant. And this case this law there's a massive campaign against it, but it's used frequently on people who've done likes on Facebook, who've said something, who criticized religious texts, not necessarily in particularly vituperative language, but they're in immediately on this. The bloggers, for example, in Shahbag, several of them were arrested under this provision. And what's particularly concerning, I think, so just to put out a picture of, not all, in fact, this is not the full list, unfortunately, but these are some of the images, which again some of you will be familiar with, of individuals who were hacked to death, murdered by extremists over the last few years. In several of these cases, these individuals sought but were not given protection for their writing in the work on the grounds that they were themselves committing the criminal offence of causing hurt to religious sentiment. And in many other cases, people were subsequently told that they had actually hurt religious sentiment or caused other offences through their work. In addition to the restrictions on speech about religion, we also see restrictions on speech about the state. So again, you see the colonial stuff on sedition, defamation, but reenacted in the same way with the protections removed and pared down. So the ICT Act has, again, that same provision. Any online speech that hurts the image of the nation, far more insidious than actually sedition even, because who determines? It's completely subjective, obviously, and also any person. any speech that hurts the image of any person. That provision has been used again for any critical comment about persons in political leadership. Again, Facebook like is enough to get you in. So you have to be very, very careful. Below the line comments on newspaper articles, watch it. It's a danger zone. Other new legislation that we've seen, there's been a real kind of industry of this kind of legislation over the past few years. One particularly problematic provision that we see popping up everywhere now is any criticism of the Constitution itself is considered to be an offence. The Constitution now includes that provision as well, which is rather extraordinary. But reenactment again of a military period law which regulates NGOs, any organisation that receives foreign donations to carry out voluntary activities, including amongst others BLAST, BRAC, huge development organisations. All of these organisations now are subject to the threat that any criticism of the Constitution or any constitutional body may result in their being penalized and also being threatened with deregistration. So you can imagine that is a fairly powerful disincentive to stepping out of line. Unfortunately, the rest of the stuff I've put up hasn't yet been enacted, but the Draft Citizenship Act says you may be, if you're not a citizen by birth, but if you're a citizen by naturalization or even by descent, you may be stripped of your citizenship for criticism of the Constitution. The Draft Digital Security Act has again some rather problematic provisions, to put it mildly, that any campaign or propaganda or criticism of the spirit of liberation, again not defined, or the father of the nation, of Bangladeshi, that will also be considered to be criminal offence. So this is our environment. Now, in this environment, how do we get work done? What actually happens? We do get work done. As I said, much does get done. Things do happen. Laws do change. They do get enforced. As Flavio was saying in the morning, you fight this, you slog on and you do win individual cases. But in terms of many large reform measures, you are really very limited in what you can do. So to give you one example of how things have changed because of the kind of context we have. Mrinali mentioned this case around fatwa violence. This was an issue pretty much recognized by the women's movement from the early 90s. And again, in about 2001, the High Court took notice of the issue, and in a case where a local informal sort of dispute resolution body had said to a couple that they would be declared divorced, and they imposed some kind of humiliating punishment on the couple. In that case, the court took suo motu notice of the matter and declared that all fatwas would be banned, all fatwas, no matter what. Very, very blunt judgment without any reasoning at all, actually. An over-enthusiastic judge, and we have many of them. That resulted in violent protests, firing on demonstrators by the police, and effectively the case kind of going into the deep freeze for some time. With the political change of government, two self-declared muftis came back to court, went to the Supreme Court. They hadn't been involved in the case at all in the High Court, but came as third-party petitioners and said that they believe that their fundamental right to, wait for it, freedom of expression and freedom of religion was being violated because as good Muslims, they had the right to receive, and they claimed as muftis, the right to issue fatwas. And they directly invoked, of course, that provision on Islam being the state religion, and they argued that all fundamental rights had to be read in the light of Islam being the state religion. So again, we returned to that time-honored practice of sitting and waiting, and we were a bit more successful in this one than in the challenge to the provision on Islam being the state religion. So we sat and waited through, I think, about 3 or possibly 4 Chief Justices and several changes of composition of the Supreme Court. And we also had to wait very cynically, unfortunately, as one sometimes has to, for the right case to happen before we went back for the hearing. And the right case was a horrendous case. It was a young woman called Henna, 14 years old, who was subjected to whipping by one of these shalishes. After actually being sexually abused, but being accused of being in an adulterous relationship with a brother-in-law, adulterous and incestuous relationship. She was raped and, in fact, very badly beaten, and she succumbed to her injuries. So at that point, we went back to the Supreme Court and mentioned this case, and it was immediately fixed. And at that point, the Mufti's representative, who coincidentally happened to be a leading light in the Jamaat Islami, was no longer able to make any argument about the right to issue fatwas of this nature. The first thing he had to concede, and he was asked that question directly by the Chief Justice, was, do you believe that there is any situation in which you can issue a fatwa which involves the imposition of a penalty or a punishment on anybody? And he had to say, no, I don't believe there's any such circumstance. Was one of his less intelligent colleagues stood up and said, sir, my lord, in some situations it is very necessary. And the chief was quite patient, says, what would be those situations? He says, my lord, when a boy and a girl holding a hand in the village, it is very necessary, it has to be done. So I think he sealed the deal as far as the court was concerned, and we knew that we had won that. We got important directives, and I should mention, sorry, I left this bit out, that one of the other strategic things we did before we went back to the Supreme Court in Henna's case is we went and filed on behalf of 5 organizations, BRAG, BLAST, and several others, a separate petition, but challenging fatwas in the way that we thought they should be challenged, i.e. not for a blanket declaration that all fatwas are illegal, but for a recognition that fatwas are an opinion, and an opinion which may be received consensually, and fatwas need to be issued in the context of recognized law. And of course that they can't constitute penalties and imposition of penalties, certainly that alone accumulating and degrading ones. And we got a very reasoned judgment from the High Court. We had, I think, also got an expert opinion from a Muslim scholar based, I think, in Amsterdam, Khalid Masood, who set all of this stuff out. And so we had a very, very pakka, solid opinion that we could go to court with. And having got the judgment we needed, laid the groundwork, we were able to then, of course, provide that to the Supreme Court when we came back for that final hearing. So we got the text that we needed and not something completely outlandish. The court also gave clear directives, of course, to relevant authorities to take action in individual cases, but they went a bit further, and they said all textbooks should include information on the supremacy of the Constitution. So a kind of careful way of trying to get in something about saying, Sharia doesn't trump, which it doesn't in any case, but making it very clear for everybody, other than family law. That, again, you won't be surprised to hear, that part of the direction has still not been complied with. We spend our time writing letters every month trying to remind the ministry that not much has happened. But the other part that happened in the judgment, which was less happy, I think, was other than the recognition that fatwas are mere opinions, the court said they may be issued by persons learned in the law on such matters. And we assume that means, and recognized as such, we assume that means not women, because they didn't specify anything about that. They didn't say what it means by learned in the law. Can someone show up like they did in the case saying, I'm Mufti, I get to issue fatwas? We don't have any guidance on that. So there's that lack of clarity. And I think, again, there was very much the sense that that provision of Islam being the state religion was partly informing that, giving that latitude. So another area we work on is probably the biggest one I think we work on is around issues of gender equality in the family and personal law. And here the difficulties we really face, and I think Lily has laid all of this out, we've had some changes in Muslim personal law in the Pakistan period and subsequently minimally in terms of registration and so on. But also we have had important judgments and so on different aspects regarding right to marry, regarding changes in custody law and so on. But what we haven't had is any change in Hindu personal law or Christian personal law. So there's very limited rights to divorce for Christian women, no rights to divorce whatsoever for Hindu women, except if it's provided under their customary law in very, very narrow circumstances. Where there's been attempts to take public interest challenges, constitutional challenges to the courts, and we were involved in one on behalf of a Hindu woman, again, the courts were very, very wary. And it was pretty much in the wake of this, the last few years of this sort of burgeoning activism of the Hifazat. And the flip side of that was, I think Khalid mentioned this very well about how the kind of extremist groups from different communities feed off of each other and kind of need each other to survive. We had exactly the same experience, that the leaders of the Hindu community, very progressive, involved in land rights movement, Adivashi rights movements, all kinds of things. But on this, absolutely no go. They came straight in and saying this case is not going to go ahead. The court agreed with it. It's gone into the deep freeze. And they found, again, a solution that particular woman, there was an argument that particular woman from her, the particular customary law that applied to her would permit her to have a divorce. So she got a divorce, she moved away, and the challenge is over for the moment. But what we also see is that there's really no appetite in the government to entertain any discussion around personal law reform. And what we've heard informally many times is when all of you lot, meaning women's rights activists or human rights lawyers, when you're out there in the streets with your lathis and you're able to accommodate or occupy the same kind of ground as the mullahs who are opposing you, then we listen to you. In the meantime, please go away and please continue to silently support us because we're the only people who are ever going to be doing what you want us to do. So I'm just wrapping up, but I just wanted to share one other case with you. I showed earlier the pictures of Juhas and Tonal, two young activists who have been working quietly and carefully around the issue of LGBT rights. One of the sort of really remarkable bits of activism they were involved in was holding the so-called Rainbow Rally on Poila Boishakh on Bengali New Year's Day. Of course, New Year's Day is celebrated across Southeast Asia. And they came up with this incredible strategy of holding this Rainbow Rally as part of the Poila Boishakh Rally, which is brought out by arts college students in Dhaka City. And there were no slogans, there were no placards. People just dressed up in the colors of the rainbow and got involved. And the arts college students had a clear understanding with them that they would make sure they would be around, they would process along, and anyone who needed to know would know, and anyone who didn't would. But then, a couple of nights before the 2016, the last rally that was held, a message was received that Al Qaeda in South Asia had directly informed the organizers that they would be under attack. So they were picked up and they were told that they had to inform absolutely everybody that they could not process and that their lives would be lost. The whole program is organized through Facebook and through informal contacts. So messages were sent out, but people come from all over the country. Naturally, not everyone got the message. 4 young men were picked up from the rally the next day. No one was killed at the rally itself, but 4 young men were picked up, held in the police station. They were finally released after Julia's intervention, but not before the police had called their families and outed them to their family members that night. In that context, Julius himself decided he wouldn't seek any police protection, though he'd heard threats as he was leaving the police station. And several days later, he and Pranay were found hacked to death in Julius's house. The investigation is still continuing, but of course, soon after that, no one was that. Unlike all the other cases where people were hacked to death by extremists and where those killings were acknowledged immediately, whether it was in the name of ISIS, in the name of some EQIS or some other group. In all of those other cases, people were able to hold public protests and condemnations in Shahbag and elsewhere. In Julhas's case, Donna's case, no one was able to hold a public protest, not to this day, because of the fear. Obviously, for the LGBT groups themselves, there was just far too much fear, but even for those who worked in solidarity, whether women's groups or others, no one was willing to come out, and they continued to be tracked down. And very soon after, the Home Minister made a statement saying homosexuality is against our culture and tradition. So that again made it very clear where things stand. And just this year, for the first time that this has happened, 27 young men were arrested from a private party, and the chief of the paramilitary force, RAB, not the police, made a statement, not the chief, a senior person from RAB made a statement saying they have been arrested because they are propagating homosexuality and they were about to engage in acts. Ultimately, I think someone spoke sense and they changed the charges and didn't proceed with that. But they spent up to more than 1 month in jail. And finally, another set of cases where we find it really very difficult to take action. We'll see the series of attacks on minorities. A particular set that happened way back after the elections of 2001. There were public interest cases asking for a commission of inquiry to be set up for investigations for action. It's 2017. We don't have reports on what action has been taken on those, despite the commission having been set up through court orders. 2013, after one of the International Crimes Tribunal judgments finding a member of the Jamaat and a very influential preacher, Saidi, convicting him for war crimes. The night after that, there were attacks across the country on the Hindu community. There was a very brutal killing. Again, the court ordered an inquiry commission, no findings of death. Attacks on Urdu speakers in Dhaka in 2014, attacks on Buddhists in Ramu 2012, further attacks on Hindu community in 2016, 2017 attacks on Shantals and Adivashis in the north, on Chakmas and Tripuras and other Paharis in the hill tracts. In none of those cases are we seeing any systematic response. Investigations remain pending, and in contrast, you see false cases being filed against the Adivashis who are victims of these situations. I just want to end with one quick anecdote and a recent situation that we're facing. This statue is the statue some of you will recognize other than the sari. All the other symbols, I think, are pretty common. This is, of course, she's described as Lady Justice constantly in our media, because it's famous, I guess. The Hifazat, our old friends, popped up again on this one and said the thing that was really troubling them now, beyond everything else, was the fact that Lady Justice had been popped in front of the Supreme Court, and the National Eid prayer ground is right next to the Supreme Court, and they said that they would be having great difficulty in saying their prayers because Lady Justice was just over to the right. But actually, if you really stand there and look at it, you would have to kind of circle around like this. But there's a big question of how they were planning to pray. But they raised the point that they would sing all tactics around the Supreme Court, but this time they would also take physical action against the Chief Justice, who coincidentally is our first Hindu and also Adivashi Chief Justice. And at this point, the court itself was embroiled and remains at this moment embroiled in a major set-to with the executive, because the executive had threatened, due to an interesting background, had not just threatened, had passed a constitutional amendment saying that Parliament could impeach Supreme Court judges. As you can imagine, a PIL was filed by some conscientious young lawyers who probably might well have had a chat with some judges, I suspect, before that. That went straight through, came up to the Supreme Court, lots of amicus there, and of course the Supreme Court struck down this amendment very rightly, I think. But this entire process was going on while the Hifazat were also coming with their demands. So very conveniently, the Hifazat are calling for action against the Chief Justice. Soon after the Chief Justice strikes down the constitutional amendment, MPs begin calling in Parliament for the Chief Justice to be sent to another country. Which would be that country? India. Why would it be India? Because he happens to be Indian. So this incredible combination of the Hifazat on the ground, kind of as the stormtroopers of a secular government, an extraordinary sight, and on the other hand, the government railing away at the Supreme Court and the Chief Justice and saying, unless we have powers to control this one last body that still stands up against the executive, nothing can be accepted. So that confrontation between the judicial and executive, that I think is now, and the use of, again, these kinds of groups to further that I think is really now the very, very critical context in which you're operating, because all of the work that we're able to do in terms of, I think, social justice lawyering, although much of it is done outside courts, is done through organizing, is done, again, as Flavia very much said, it's not just about the laws and the institutions, it's about the people and the practices. That's absolutely correct. But you do need to have some institutions in place and not completely teetering over the edge. And I think the situation we're in now is very much at that moment of teetering, and the question for us is how do we keep it standing and how do we keep working?
Thank you, Sara, for that lovely talk. And I will be in charge of the mics. I'll take that around for questions. But I'm going to use my prerogative as chair to start off the questions. But you don't have to answer them right away. We can collect a few questions and have you respond. That was really marvelous talk, but I guess very depressing to kind of think of the shrinking spaces, as you so rightly put it. I was wondering if I could ask you, especially since you brought up the question of the Supreme Court judgment on Islam, refusal to accept challenges to Islam as a state religion. From what I heard you say, that the decision is a sort of ambiguous decision, that it was decided on the grounds that those people didn't have local standard to make their case. So does that make you feel that there is opening now to kind of start that case again, to be institute that case, or is the climate such that that is de facto, going to be impossible to challenge? And related to that is that you focused a lot on the importance of institutions in Bangladesh, and I think that's really important. But I wonder whether the international context, especially in terms of donor agencies for a lot of the non-governmental organizations that put up some of these challenges, whether their priorities and how they kind of operate is also another constraining force for the shrinking spaces. Yeah, sure. I don't know.
So I just blank. What's the first one?
The first one about whether there is room still.
Yes,
for the
that's
challenge.
right. Yes, there is.
The nature of the judgment.
Yeah, sure. Yes, I think there is, because they knocked out the case on locus on standing, but there is a remaining petition actually, which they weren't able to knock out on that occasion, which is relating to the newer amendment. So they knocked out the case from 1988, which had come up again, the old case. But then Islam as a state religion was retained by the current government in a recent amendment as well, and there was a challenge made to that. And that remains somewhere in the docket. So it could be revived. I think it wouldn't be revived at this particular moment. And I think that there is also exactly that sensitivity. There was a sense that because of the current Chief Justice, it would be particularly awkward for him to be, around when this is being heard. At the same time, you also felt, well, maybe he would give it a bit of a hearing. But I think right now, with the confrontation going on, it's impossible to imagine that moving forward. And in terms of the issue around donor agencies, I think now actually a lot of PIL is not coming just through NGOs anymore. A lot of PIL is done by individual lawyers. We actually have a real problem, I think, with some kind of PR type of PIL, where particularly I think lawyers who are trying to get themselves known will go off and file a couple of PIL, get a few headlines, and then they're going to move on. They're not really interested in that case or what happens to it, but they've got known, they've done a quick 5 minute for the news and so on, and the clients will come in. Another example we see, which is even more problematic, is people coming forward as being public interest lawyers, but then going off and representing exactly the state agencies against whom they filed this petition. So, I mean, that's, I guess, not very healthy practice. But going back to the kinds of public interest that is filed, I think we are seeing that because of the standing rules having been so liberalized, many lawyers themselves are coming forward with petitions of different kinds. And not just the public interest groups, the 2 or 3 that before used to do cases, the environmental lawyers, blast us, and so on. I think it's spread much beyond that. So I think donor agencies or not, the work will continue. But I don't think there's so much an issue of donor agencies pushing particular issues. But I think maybe they've also been more educated than they were about the fact you don't have to go off and file a petition and show that you've done something, and that these cases require actually nurturing and ongoing steps, and that's the kind of work that they need to support now.
Just a comment, question, and to add to your introduction, one thing that is not on her professional bio, it must be said that Sara Hossain is a great mother and a great wife and a great hostess. I've had the pleasure of getting to know her better. I'm a Moshmi Khan, a civil rights lawyer who moved to Bangladesh and worked in development. And one of the things, my question is very direct, is how would you compare the Bangladeshi judiciary independence as compared to India? Recently, I was surprised to hear someone from India say, like 2 days ago, how he's struck by how independent it is. And it seems our judiciary has been very, let's just say, not as independent. And the comment that I have is, I was someone born during that war, 71, and who grew up in the U.S. and grew up in Ann Arbor, and so, welcome to our hometown. But I moved to Bangladesh in 2010 for many years, and one of the comments that I don't know if I've shared with you I think I have privately, but it really struck me is that because of all the political instability or whatever you want to say, it was very difficult for me as someone who, let's say, I'm Muslim American, who has strong views on civil liberties, but also my right to practice. I feel that things in Bangladesh have become very binary when perhaps they're not in reality. And what I mean by that is that, that that it seemed that the government, particularly I moved right when this new government was in its first term, was very secular, and the civil society was very anti-religion, and the religious sentiments really didn't represent what I felt, right? And so, and yet at the same time, I remember getting into a very heated discussion with our friend Naeem about Jamaat and the space for public discourse, right? And I feel that that's still something that has been really fraught. And I feel even Bangladeshi civil society or the bourgeois is quite, I don't want to belabor the point, but I think it is worth mentioning because I wouldn't have realized if I didn't live there, and that it is very fraught with, it's so much, not just more complex, but I don't feel comfortable, and I feel in a way, whereas I feel more comfortable in the U.S., and that's something I rarely say, particularly now. And so I guess that's something that I'd love for you to kind of touch on.
You want to take a few more questions?
Thanks, Sara, for taking the trouble to come and to share some of your work with us. My question is a little inchoate. It's not yet well formulated, but I think it has something to do with the fact that I'm trying to understand the landscape that you're operating in. And it seems that there are both kind of state actors, right? You've made mention of kind of authoritarian tendencies coming from the executive branch. So there seem to be state actors that you're contending with, but also, of course, non-state actors. And so the question perhaps is, to what extent is the nexus between those two contributing to not just, the diminishing spaces in society, but I'm also thinking about your ability to operate in this legal landscape, because it seems like the struggles are becoming, in a sense, more complex, perhaps, as we've seen this increasing nexus between state and non-state actors. Or do I have that sense that it's an increasing nexus? Maybe that is not accurate. So, sorry, that's not a very, it's a slightly inchoate question, but I'm just wondering maybe more about the landscape that you're operating in and the impact of both state and non-state actors on your ability to operate.
One more question.
Hi, thank you also for compiling all this information and presenting it to all of us in a very contextualized manner. I had a question about the organizational kind of aspect. So for me, it's really important to think about like the driving forces behind organization, especially legal organization that's surrounding policy and legality. I wanted to know, because you mentioned that there's a consistency in the lack of systematic response to a lot of attacks against ethnic and religious minorities and women across all those landscapes. So what is the driving force then behind wanting to use the law as a mechanism for social justice?
Based on answering, so maybe there's a connection between Farina and Moshe, both your questions. So I think perhaps I didn't speak about it clearly enough. But I think there's a rising, but I think something that's been written about Bangladesh a lot in the last sort of 15 years, I think kind of the post, or 20 years now, post-military years, is about as we came out of a simpler, easier time in a sense, so we knew that we all confronted the military, with the kind of growth of electoral politics, political polarization has become very extreme. And that's obviously affected civil society, citizens groups quite severely. So people fall into separate camps, and it means you don't have the kind of unification that you would need really to take certain issues on, and in the kind of way that you would have been able to take them on before. But I think what we've seen in the last, I think we saw that situation really up until sort of 10 years ago, up until we had the caretaker government and 2 years of emergency. After that, we had the Army League coming to power with an enormous mandate, with a huge amount of goodwill. And in that first administration, I think there was a lot of positive work done, but a lot of proactive legislation, a lot of citizen engagement, consultation, and so on. But I think you could also see the seeds of what was to come later. Subsequently, we had this sort of controversial election with the opposition boycotting it and so on. And subsequently, I think what we've seen is, as we've gone closer and closer to really having effectively, a one-party or one coalition process without any real sort of contested, democratic politics or practice, it becomes much harder to operate as citizens' organizations which are going to be engaged in advocacy in the way that we would have imagined it within a more easily comprehensible democratic framework. And when you talk about non-state actors in that situation, of course, we also see the rise of this kind of very different kind of fundamentalism or extremism, right? The kind of violence of Al-Qaeda or ISIS or what have you, this spate of killings that we had, that's created a very different environment. And I think people haven't had to work with that level of extreme and arbitrary violence before. And then the response of the state mechanisms to that, to not look at the causes, not try to combat it, but to respond to it with arbitrary violence of their own, with disappearances, with unaccountable responses, and so on. That creates another kind of syndrome of anxiety and fear, and the very real possibility, I think, that people can simply be picked up and removed, and you don't have anywhere to go for that. So that's definitely been part of it. And I think the other aspect in terms of non-state actors, I think, which is relevant, which we really haven't worked on very much, partly precisely because of the kinds of frameworks we have to operate in, is in terms of political party members and the role that they're playing. So, for example, youth wings of the political parties, their imbrication and involvement in acts of violence, whether violence against women, violence against minority communities, a lot of it actually coming out, and particularly the violence against minority communities, that entire list I showed you, all of those cases are really catalyzed by conflicts over land and property in any event. And we've had quite a lot of work done in Bangladesh showing that those kinds of conflicts are being engaged in by the ruling party of the day. It's not so much that simplistic story that it's BNP Jamaat doing all of it. It was doing a lot of it when it was in power. But when it's not been in power, which is the last 10 years, unfortunately others we would expect better of are also involved in the same processes. And there is police action taken when there's a protest and so on, even against ruling party members. But what happens in the end? How many of those cases go anywhere at the end of the day? What is the investigation process and so on? So I think that there's a real issue about non-state actors being very much now a part of and the nexus between non-state and state and how that operates. One of the very common concerns now is in terms of, for example, I was talking about the erosion of institutions. So particularly with the police, for example, extreme politicization of the police. We're all used all across South Asia to be politicized, but the extreme levels of it, the extreme use of localized networks and connections, particular districts, police coming from particular districts with particular connections to particular ruling party leaders, and then having those particular clients as networks that are then engaged and activated. And the final question I think was around organizations, right? And you were talking about how does one deal with the problem that how do you sustain a response in these situations when there isn't action? I mean, courts are directing something to be done, you're campaigning for something, but you don't get any response from the state. I think that is one of the big weaknesses that we face, actually. Firstly, the over-reliance on creating newer laws all the time without working. Again, I think Flavia spoke about this very eloquently this morning, that very often there are remedies sitting there that need to be used and that actually require you to put in place people, put in place processes and practices and be systematic about how you use them. And I think that connects back to the point about donors, actually. That is definitely a problematic area where you see donors being very happy to put down their euros or put down their dollars to say, okay, create a new mechanism, pass a new law, do something else. Don't just go and use stuff and make it better. Don't work on monitoring. Don't work on building solidarities and alliances that actually operate. And I think quite often actually organizations do fall into those traps and don't build these bigger structures. The other difficulty I think is in terms of sort of really, I think in Bangladesh particularly, with development organizations being as successful as they have been, but also I think being victims of their own success, right? Because precisely because of being in a development modality, often the kind of mobilization they're willing to do will be limited to certain kinds of issues. They won't go beyond that, to particularly taking on state power, particularly where there are really major political conflicts that have to be taken on. So I think those are some of the big challenges, and that's why it's a very good question that you asked.
My question is very obvious, maybe, but why do you do what you do?
Because it's really interesting. Because I think you see things happen at the end of the day. I wish I didn't do some of the things I do. Like I wish I didn't do running an organization, and I wish I didn't do fundraising. I hate those things, and I do not enjoy them. But I think when you get to do a case, or you get to work on any legal analysis or reforms, you feel a tremendous sense of satisfaction in what you're doing, and that keeps you going. And I think actually, as I said, this whole unwieldy, creaky system, which is in all kinds of malaise, but there are so many people inside that who are suffering, who are feeling the same levels of frustration and angst that you feel. So being together, I think, is what keeps you going.
My answer would be very simple. I don't know.
Yeah, I say I agree with that.
I have another sort of abstract question, and that you often refer to the time-honored South Asian judicial mechanism of letting things chill out for a few decades, and judicial backlog, and we all know how clogged the courts are, and things get set aside. Would you, in another world, would you want swifter action in the courts, or are the kinds of people coming who do have locus to argue a case or to submit a petition or an amicus, isn't that kind of maybe where the democratic process is located right now?
Yeah, you would, of course, want swift action in many, many cases, for sure. But there are some cases, I think, where the delay is quite helpful. So, for example, in some of the cases where it's been most helpful so far, of course, you get to the end of the tunnel, and we are reaching that. But on forced eviction cases, for example, where we've had stay orders in place for years and years in many cases, it's very useful to keep those out of everybody's eye and keep stay orders and keep protections in place to the extent that they're recognized. And I think actually I didn't speak about that today just for lack of time, but I think one of the other huge pushes now, of course, is with this whole development of democracy kind of discourse we're in. So it's one of the situations we're facing now is with these mega infrastructure projects coming in with Chinese money and Russian backing and all of this kind of thing. None of those familiar international human rights settlement schemes and other things that we used to like to bash them as not being good enough. And now actually I wish to God to like them back, because no Chinese business is interested in talking about any of that, nor do they have it in any of their contracts. So now I think we're coming to the end of the line where so far, interestingly, government has been more or less respectful of these kinds of court orders in these eviction cases. But now I think when the mega bucks are coming in and the mega projects are coming in, I think it's going to be a very different situation. I don't think delay will actually save us for much longer on these ones. So the interest is just too high.
That's it. My question is, as somebody practicing in Pakistan on some of the similar issues, how do you deal with Islam? Because that's something that we struggle with. So on the one hand, we get this criticism that we operate in a very secular context, and some of the issues that we deal with, for example, women's rights, there is no going around Islam, because at the end of the day, gender relations in our society are determined very much according to Islamic principles. But as people who are working in NGOs and within the human rights community, if we do begin to engage with Islam, another criticism that we face is that we're kind of getting ourselves co-opted into some of those things that we are trying to fight against, because at the end of the day, you are reinforcing something that you have been struggling with. So, that's something that we struggle with, and I know it's on a case-to-case basis, because in each different case and circumstance, there's a different situation. But I'm wondering how you balance that in your public interest litigation. Do you rely on arguments in Islam because sometimes it's necessary, or do you just not deal with it altogether?
You have to use it, like in the fatwa case, obviously we used it with that expert opinion and so on. But we're fortunate in that, unlike Pakistan, we don't deal with Sharia in terms of criminal law. We only deal with it as we deal with Hindu or Muslim or Christian or Buddhist law. So for family cases, of course, you use interpretations where you can, but you also try and use so in custody cases, you'll use a combination of interpretations about whatever Amir Ali said or somebody else said, but you'll also try and use the welfare principles and so on. So I think we're more strategic about it. And there was a period earlier when I think more in the late 80s, early 90s, when there was a lot of discussion around whether we would, go down that route of trying to use reinterpretations and feminist reinterpretations and so on. But I think there has been limited interest in that. And other than I think there's one international network called Musawa, which can you involved with that? Yeah, they're doing quite a lot of work and research around this area. But other than that, I don't think it's a very mainstream.
Yeah, the conference I came.
So I think we're probably at the end of our time. So if you were round of applause.